What if the Supreme Court just shattered every gun control advocate's plan with one unprecedented move that could restore Second Amendment rights for 85 million Americans overnight? The court issued an extraordinary writ in Duncan versus Bonta, breaking their own procedures to fast-track California's magazine ban case immediately. Gun control groups are in absolute panic mode, funding legal teams because they know this signals something massive. Subscribe now to get the latest cases and updates that affect your freedom every day. The shocking Supreme Court. The shocking Supreme Court move. Here's exactly what happened that has every constitutional lawyer buzzing and gun control advocates scrambling for damage control. The Supreme Court didn't just accept Duncan versus Bonta for review. They issued what legal experts are calling an extraordinary writ, completely bypassing the standard petition process that typically takes months. This procedural bombshell is so rare that it's only been used 12 times in Second Amendment cases since 1950. Constitutional law professor Jonathan Turley immediately called this action unprecedented in modern firearms jurisprudence. When the highest court in America abandons their traditional timeline and fast-tracks a case, they're sending a crystal clear message about their intentions. This isn't bureaucratic efficiency. This is the Supreme Court signaling they're ready to make major constitutional law that reshapes America. The last time we witnessed this level of urgency was with District of Columbia versus Heller in 2008, and that decision fundamentally transformed Second Amendment interpretation nationwide. California's magazine ban suddenly finds itself under the microscope of a Supreme Court that has already demonstrated increasing skepticism toward gun restrictions. Duncan versus Bonta isn't just another case on their docket. Why gun control? Why gun control groups are in full panic mode? Groups are in full panic mode. The anti-gun establishment is in complete crisis mode right now, and the numbers behind their panic tell you everything about what's really at stake. California's magazine capacity restriction turned 4.2 million law-abiding Californians into potential felons overnight, simply for possessing standard capacity magazines they legally owned for years. But California was never the endgame for these gun control zealots. 11 states have copied California's playbook, creating a patchwork of unconstitutional restrictions that now affects over 85 million Americans living under magazine capacity limits. That's nearly 1/4 of the entire country, stripped of their Second Amendment rights. The Brady campaign has sent out 5 separate fundraising emails in just 24 hours, literally begging for emergency donations to fight what they clearly recognize as an existential threat to their entire agenda. Why are they so absolutely terrified? Because legal analysts across the political spectrum are predicting that if the Supreme Court strikes down California's ban, it creates binding precedent that instantly invalidates magazine restrictions in New York, New Jersey, Connecticut, Massachusetts, Maryland, and 6 other states. We're talking about the potential restoration of Second Amendment rights for nearly 1/4 of the entire American population in a single Supreme Court decision. Shannon Watts from Moms Demand Action actually tweeted that Duncan versus Bonta could undo decades of progress, and that public admission tells you everything about how significant this moment really is. When gun control advocates are openly acknowledging that one Supreme Court case could dismantle their legislative victories spanning multiple decades, you know they understand the stakes better than anyone else. California Freedom Week. That California Freedom Week that destroyed their arguments. Let me tell you about 7 days in 2019 that completely demolished every single argument California has made in Duncan versus Bonta when federal judge Roger Benitez temporarily blocked California's magazine ban, creating what gun owners celebrated as Freedom Week. Something absolutely remarkable happened that exposed the complete lies behind magazine capacity restrictions. In just 7 days, Californians legally purchased over 1.2 million standard capacity magazines. Gun stores across the state reported lines stretching around city blocks, with some locations moving 10,000 magazines in a single day. This wasn't chaos or panic buying. This was pent-up demand from millions of law-abiding citizens who had been criminalized for wanting to own standard firearm components. Gun control advocates had spent years predicting blood in the streets if Californians could access standard magazines again. They warned of immediate spikes in mass shootings, gang violence, and accidental deaths. Freedom Week put those fear-mongering predictions to the ultimate test with real-world results. The outcome: zero increase in crime, zero mass shootings, zero of the catastrophic consequences that California's lawyers had promised would follow. FBI crime statistics from that exact period actually showed a slight decrease in violent crime compared to the same week the previous year. Background check approval rates remained at 94%, proving that criminals weren't the ones standing in those lines. This real-world evidence is now part of the official record in Duncan versus Bonta, and it's absolutely devastating to California's defense. Legal dominoes already falling. Legal dominoes already falling. The Supreme Court hasn't even issued their ruling in Duncan versus Bonta yet, but the legal and political landscape is already shifting dramatically. 3 federal judges in different circuit courts have postponed their decisions on magazine ban cases, specifically citing the pending Supreme Court review of Duncan versus Bonta. That's legal code for we're waiting to see which way the constitutional wind blows. New York Attorney General Letitia James quietly pulled 2 magazine-related prosecutions from court dockets last week without explanation. Colorado's legislature just indefinitely tabled a magazine capacity bill that had seemed guaranteed to pass. These aren't coincidental timing issues. These are politicians and judges realizing they might end up on the wrong side of Supreme Court precedent. The financial markets are already pricing in a massive gun rights victory. Gun rights organizations report a staggering 340% increase in legal defense fund donations since the extraordinary right news broke. Manufacturers like Magpul and Remington have increased production capacity by 60% in anticipation of restored markets in restricted states. Wall Street analysts have upgraded firearms industry stocks across the board, with some companies seeing 15% gains in 2 trading sessions. Even liberal legal scholar Erwin Korinsky admitted that Duncan versus Bonta presents troubling implications for gun control advocates. Historical evidence that seals the deal, Here's the historical evidence that makes California's position in Duncan versus Bonta constitutionally indefensible. The Supreme Court's new standard from Bruin requires gun restrictions to have clear historical precedent from the founding era, and California's magazine ban fails this constitutional test spectacularly. The Founding Fathers knew about high-capacity firearms and deliberately chose not to restrict them. The Girandoni air rifle, capable of firing 20 rounds in rapid succession, was so impressive that Thomas Jefferson personally equipped the Lewis Wiss and Clark expedition with these weapons in 1804. Rather than viewing multi-shot capability as dangerous, the founders celebrated it as American innovation and military superiority. During the Revolutionary War, Pennsylvania gunsmiths created rifles capable of firing multiple rounds rapidly, and George Washington's Continental Army used them effectively against British forces. By 1791, when the Second Amendment was ratified, multi-shot firearms were common enough that the Continental Congress actually contracted to purchase them for military use. Zero historical evidence exists of colonial governments limiting magazine capacity despite having both the technology and legislative authority to do so. Legal historian David Kopel's research now cited in 14 federal court decisions documents over 200 examples of early American firearms that held more than 10 rounds. His exhaustive findings show 0 examples of founding-era governments restricting magazine capacity. California's attorneys have spent years desperately searching for historical precedent to justify their magazine ban and found absolutely nothing. They can't point to a single colonial law, founding-era regulation, or early state statute that limited magazine capacity because none exists under the Bruin standard. That complete absence of historical precedent makes their ban constitutionally doomed. Immediate impact on your rights. Immediate impact on your rights. This Supreme Court action in Duncan versus Bonta creates immediate practical changes that affect your constitutional rights today. First, if you're a California resident who purchased magazines during Freedom Week in 2019 or owned standard capacity magazines before the ban took effect, you remain legally protected throughout this entire appeal process. Second, gun owners in restricted states should start preparing now because manufacturers are already ramping up production capacity in anticipation of market reopening. If you live in New York, New Jersey, Connecticut, Massachusetts, Maryland, or any of the other restricted states, favorable Supreme Court precedent in Duncan versus Bonta could restore your rights faster than anyone expected. Third, other Second Amendment challenges are being fast-tracked by lower courts anticipating favorable Supreme Court precedent. 3 separate assault weapon ban cases and 2 concealed carry restriction cases have received expedited hearing schedules in just the past 2 weeks. Law enforcement agencies are already signaling how they'll respond to a Crown ruling. Sheriff Chad Biano in Riverside County publicly stated his department will not confiscate legally owned magazines from law-abiding citizens if the Supreme Court strikes down California's ban. Conclusion. The Supreme Court just made an unprecedented move with Duncan versus Bonta that's about to transform Second Amendment law across America. This case isn't just about California's magazine ban anymore. We're looking at the potential restoration of constitutional rights for 85 million Americans currently living under capacity restrictions in 11 different states. The extraordinary writ, the complete panic from gun control organizations, the real-world evidence from Freedom Week, the legal dominoes already falling, and the total absence of historical precedent for magazine bans all point to the same inevitable conclusion. Duncan versus Bonta is positioned to become the next landmark Supreme Court decision that expands gun rights nationwide.